There are very few things more exciting than being in the courtroom for me. It's exciting because there's a sense of exhilaration, there's some adrenaline. Something is going to happen today. We are going to receive a result. We are going to have an outcome. The case is moving forward or ending, and this is essentially a test, quiz, or the final exam. To that effect, one way that we prepare as family lawyers and likely lawyers in general for any court proceeding is by researching case law. We subscribe to LexisNexis. Some firms subscribe to Westlaw. These are excellent legal research services. They provide Florida statutory updates, secondary sources, but the real gold is case law. Case law is so much fun to research. It is painstaking in its own way. It takes hours upon hours upon hours of time, but it allows us to develop memoranda of law or laws in our minds and on paper if we need to submit one to the court. To that effect, I just researched random case law about a topic that is increasingly frequent in divorce cases, infidelity, and its impact on equitable distribution and or alimony. So here's a case, Weininger versus Weininger, 290 Southern 3rd, 928. This is from the District Court of Appeal, and it involves lots of issues: property distribution, equitable distribution, spousal support. I believe it involves attorney fees. This one dates back to when permanent alimony was a thing in Florida. That has been since abolished in 2023. And we are here. I just said 2023. I apologized. In 23. I'm so excited to read this case. I misspoke. And here we go. I first look to the head notes to get a sense of what the case is about, and then the outcome. If it seems as though it could go against us or have a favorable outcome, and it has a factual similarity, that may be a case we want to introduce at the court proceeding. Here we go. I'm going to read to you a little bit about this case. It should be entertaining, and it is so interesting. Throughout the marriage, the husband was the primary breadwinner. He was an Air Force pilot. He retired, and then he became a pilot for a major airline. The wife worked specifically part-time and was a, quote, homemaker and made career sacrifices while her husband would travel. The kids went to private schools, and they paid for college education for the children. They purchased a family home, and they purchased land. Husband acquired several retirement accounts and insurance policies. Some of those benefits were not shared with his wife for whatever reason. Wife also acquired her own funds, an IRA, and then received $9 million in a lawsuit, in a very famous lawsuit, which is just absolutely incredible. Okay, there were allegations of infidelity in this case. Back to our primary topic here. The parties separated, and the wife filed for divorce. The husband had moved out into an apartment, into another state with his mistress. While the parties were separated, husband continued to pay for the mortgage, taxes, and insurance for their marital home, but did not pay for the out-of-state property. The wife covered many of the expenses and received rental income. The wife argued that the husband had done what we call dissipated marital assets, specifically that he had spent marital monies on his mistress and his mistress's son, and therefore failed to provide for his own family, causing wife to use her own personal funds to support marital expenses. She claimed that she was entitled to permanent alimony and so on and so forth. That really is not an issue for us here today because that is not a topic of conversation. We will cover that in the future. Why Florida did away with that, how many people advocated for such a long time to have that permanent alimony portion of the statute abolished, and so on and so forth. So this passed the trial court level. The wife appealed. It went to the District Court of Appeals. And here is some of the analysis from the District Court of Appeal. And everything I'm saying is paraphrased or my own analysis. I'm not reading verbatim. And to the extent that I do, I'm not including all details and names because there is still a modicum of the privacy of this whole thing. Here, the wife alleges that the retirement account constituted marital funds. Her husband wasted them, he spent them on somebody else, and they were separated. She claims that he spent the monies on attorney's fees, taxes, furnishings for he and his new woman, and that he used his salary for reasons that we shall say are unseemly. The court, however, ruled that because the husband's only source of funds to support himself was his retirement account at this point, based upon the circumstances of his finances and their marital separation, that it was justifiable that the husband used that retirement account. Yes, he depleted what could be considered a capital asset, but the trial courts and the district courts of appeal now abide by the standard of this. One party's use of an asset, this part is verbatim, I apologize, this is in quotations. One party's use of an asset out of necessity and for reasonable living expenses does not justify depletion of marital assets or any kind of misconduct, and therefore the trial court deemed that the husband's conduct was fine. He didn't necessarily take from the wife's money and leave her impoverished. She had already won a lawsuit and she had her own retirement account. Essentially, the court determined that he spent those monies on regular everyday living expenses. They were already separated anyway. And just because a girlfriend slash paramour slash mistress may have lived with the husband, that doesn't necessarily mean that the husband has done something wrong by spending money for an apartment. After all, he needs a place to live. These parties are separated, and he wasn't doing so maliciously. He wasn't wasting money. He was using it for needs and necessities. And therefore, let's go back to a guiding principle in Florida family law. Florida is a no-fault divorce state. No fault means you do not have to prove as a husband or a wife or a spouse, whatever the case may be, you do not have to prove any sort of infidelity, any wrongdoing at all. You do not have to prove misconduct. You only have to allege that your marriage is irretrievably broken. The standard in Florida is very, very different than it is in many states. In some states, you have to prove that you need to get a divorce and that there's good reason for it, and the court and the legal system has to accept that reason. This has been, I hope, for all of you, an interesting episode of the Best Florida Family Law Podcast. My name is Attorney Jonathan Jacobs of the Jacobs Family Law Firm. We do not intend for anything said here today to constitute legal advice. This is strictly for entertainment purposes and to perhaps give you an opportunity to educate yourselves about Florida family law, the law in general, and we hope you will do your own research. Have a wonderful weekend, friends. Thank you.